papers, if any? If not, we can discuss it right now. Anybody would like to raise their hand and let me start with Mr. Chikianko because I'm very familiar with him. Cal, what do you say about this bill?
Well,
This
of
is
course,
this is the last part of the trilogy, no?
yes, that's correct, Your Honor. This will have a huge effect for the farmers because right now, I think it will expire. The right to patent agricultural land will expire at the end of the year. So it is important that we extend this right. Instead of specifying a period, it can be farmers can file a patent at any time. Secondly, of course, this will help simplify land titling procedures.
Right.
So, so those are the very reasons we need to, I think, pass this bill. It's not a controversial bill. I think many of the rural bankers here and the developers will be supporting this bill.
This will mean allowing the farmer, as we did in our first two bills, that allowed him to get a title, no, to be sure that they can perfect the title even beyond the reglementary period. In fact, they can now do it at any time.
That's correct, Your Honor.
And at the same time, this will allow them to be able to borrow money against the land. And at the same time, have their children inherit it if they need to. And there's a limitation of 12 hectares, right?
Yes, yes, Your Honor. Although, in fact, because of Carl, actually, it's being limited now to about 5 hectares. Am I not correct, Tony Johnson?
Jerry Johnson?
Yes po, under call po, the limit is 5 hectares. But in the Public Land Act, we always put the constitutional limit, which is 12 hectares po at present under the 1987 Constitution.
Right. But under car, you're limited to 5. Are they covered by
Yes
car?
po.
They are covered by car?
Yes po. The DNR has, gives only 5 hectares maximum because of the call to
All right.
free patent applicants.
Yeah. Are there any other comments? This is practically motherhood. Yes, Attorney State Counsel Lorena Calo. Are you the only one, Miss Calo?
Father side po, sir.
Yeah, yeah.
But I've never been there.
That's too bad. You should go there.
Maybe someday, sir. In general, the department interposes no objection to the passage of measures seeking to amend the Property Registration Decree and the Public Land Act, since it resonates well with the state policy to promote social justice. However, some initial observations, and we will also be submitting our position paper later. Initial observations would be the subject matter of CA 141, Section 4748, and Property Registration Decree, Section 14.1, seem to be discussing altogether different matter from each other. Based on the matrix, the proposed amendment seeks to harmonize these two bills. However, judicial confirmation of imperfect or incomplete titles under CA 141 applies to agricultural public lands or public lands suitable for agricultural purposes, as manifested by Section 11 of the Act. Enumerates judicial confirmation as one of the modes by which agricultural public lands may only be disposed of. On the other hand, PD 1529 is it deals with land registration. It provides for the procedure to register a title under the torrent system. while judicial confirmation allows for agricultural public lands to be disposed of by the state and acquired by Filipino citizens. So I don't. I'm just pointing out some initial observations as to the differences of the two bills, sir. That's all.
But there are no fatal defects here, are they? Ma'am, there are no fatal defects here that you see, Lorena?
Initial observations po sir dun sa proposed movements. Yung sa PD 1529 po kasi it deals with land registration lang. So I don't think there's a need to harmonize the two since I don't think they are in conflict with each other.
So we
Just
can
like- just-
proceed.
Sir.
So we can proceed with the taking a committee report and pass it because it's really, really very simple. There are no contradictions, right?
I think there would be a contradiction, sir.
Oh, that's what I was asking you.
Yes, sir. Sorry, sir. Because it seems that the purpose of the Public Land Act is to for the farmers to at least have the chance to own the land. However, the property registration decree PD 1529 only deals with land registration for all types of land. CA 141 exclusively deals with agricultural public lands.
So, free patent. Is that the contradiction that you're referring to?
Sir, can you repeat, sir?
2 years ago, this representation filed this bill RA 11231, agricultural free patent. We removed the 5-year prohibition on encumbrance. Right? There used to be a 5-year. You cannot encumber it, right? When you get the patent.
Okay,
Be
sir.
aware of that.
Yes, sir. Sir, I'm just referring to the initial provisions regarding harmonization of PD 1529.
You need to harmonize. We removed the 5-year right to repurchase. We removed the prohibition on corporations, associations, or partnership to acquire or hold an agricultural free patent. This is for a this is for a farmer.
Sir, I'm only referring to Section 2 of the Senate Bill. Section 2 on judicial confirmation of imperfect title.
Yes.
Yes, sir. Because Section 2 seeks to amend PD 1529 and CA 141.
Where is that?
Section 2 of Senate Bill 1268, judicial confirmation of imperfect title.
Actually, yeah, the bill only, the bill's main purpose is to remove the period to file. Ano naman ang purpose ito? Ano iba eh? Wala nang prohibition to file. I think like the December 2020, if I'm not mistaken, hindi na sila makakapag-file. Kawawa naman sila, they'll be forever in bondage. So if you remove this, they can now file. Let's say, where is there a disharmony there somewhere?
Sir, just to clarify, sir, I'm not referring to regarding the deadline of the filing of the patent. I'm referring to Section 2 of the proposed amendment, which states that the qualifications provided in Section 14 of PD 1529 and Section 48 of Commonwealth Act 141 shall be amended to read as follows.
Yeah, I'm reading it.
Yes, sir. And it says further that Section 14 would be amended based on the provision. Section 14 would be amended in such a way that it would harmonize with Section 48.
Section 48. Yeah, I know. Section 48.
48 of Commonwealth 141. So.
All right, Section 48. The following describe occupying lands of the public domain, claiming to own any such land or may apply to the regional court. Is there something wrong with that?
Sir, PD 1529 deal as opposed to Commonwealth Act 141. Section 48 provides for judicial confirmation of imperfect title, and it specifically applies to agricultural public lands, while PD 1529 provides for land registration of all types of land, sir. If we would read the original PD 1529 as is, actually the judicial confirmation of imperfect title may fall under its paragraph 4. Those who have acquired ownership of land in any other manner provided for by law, sir. It may fall there. So
you know,
just some initial observations, sir.
Erwin, Erwin Johnson.
Just for clarification lang po, yung actually Section 14 and Section 48, if you will look at the wordings, it's all June 12, 1945. These are all refers to confirmation of imperfect titles. Because Section 48 is agricultural land. When we talk about agricultural lands in the Philippines, it also includes residential, commercial, and all. These are two provisions that have been in existence only in 1978 after PD 1529 was enacted. It forgot to remove the Section 48 because that is the same actual provisions. This what we call this long-time possession, which is the basis for acquiring ownership. So when you invoke Section 14, you are invoking long-time possession since June 12, 1945. When you invoke Section 44, you are also invoking long-time possession since June 12, 1945. So it's just actually the same. So the Senate's effort to harmonize it is actually very helpful to remove the seeming confusion, so that we will now all be looking towards just one long-time possession. And the shortening of the period to 30 years will be very helpful to everyone. Because as it is worded right now, Section 44 and Section 14 requires 75 years of possession to prove ownership. Very, very hard to prove. And it requires not only tax declaration, but testimonial evidence. That is why a lot of cases are now being thrown back to people. They can't title because of the very tedious requirement. So we support the Senate's effort to actually shorten it to 30 years. In fact, Mr. Chairman, if you will remember, in our effort in Republic Act 123, you even shorten it to 10 years. Because as you said before, the 30 years possession under the civil code in bad faith, we can actually use the 10-year possession in good faith under the civil code. So in RA 123, the Senate shortened it to 10 years, which the effect of which is the issuance of 500,000 residential free patents. Right now, we empowered our people by giving them titles. 500,000 of them are now recipient of our Republic Act 123 law. So putting this provision to 10 years or 30 years and removing the 75 years of requirement will help a lot of our kababayan, sir.
I agree with that. I think we're just trying to make it easy for the farmer to finally own his land and finally have his chance under the sun of this country. Di ba?
Yes, sir.
Attorney no, Lorena?
Yes, sir.
I think we can live with that, can't we?
Sir, I'm not expressing any opinion regarding I mean, sir, I think if the purpose is to make the process easier, or make it the process easier for the farmers to acquire the land, I think what should be amended is Commonwealth Act 141 instead of PD 1529, because PD 1529 does not vest or create a title to a public land that has already existed or has been vested under Commonwealth Act number 141, sir. I'm sorry if I'm not making myself clear. Magkaiba po kasi yung subject matter ng dalawa. So, yung subject matter nung PD 1529 solely deals with land registration. So, yung si Commonwealth Act 141 naman po, nagpro-provide po siya ng yung mga provisions po niya, ini-enumerate yung mga kailangan para ma-acquire nga po yung mga agricultural public lands. And if ever na compliant with if ever compliant po with Commonwealth Act 141 with the requisites under the law, then they can then register the land under PD 1529, sir.
Are there any comments? Because I'm confused right now. Attorney Katigbak, do you have a comment?
Sir, yes, sir. Sir, PD 1529, Section 14, and Section 48 of CA 141 deals with the same subject, sir. It is the same kind of land.
Which
They
section are
are-
you talking about in Commonwealth Act 141?
Section 48, sir.
38,
48, 48.
38, 38.
48, sir. 48.
38. Okay,
Yes, sir.
naman.
Section 48 and of CA 141 and Section 14 of PD 1529 are similar provisions, sir. They deal with the same kind of land, public agricultural land.
Oh.
So I'm confused with DOJ's opinion that they're dealing only with property registration. Although although PD 1529 deals with the registration of property, it also provides the way, or it also provides the procedure on how or who are qualified to own that agricultural land. So pareho lang, sir, sila pareho silang provision, sir. That's why we are harmonizing it into a single provision na so that hindi po, sir, nakakalito. Yun, sir. Yung ano.
The real object here is to simplify the farmer who cannot afford the lawyer
Yes.
most of the
Yes,
time.
Your Honor.
Hindi
Yes.
makaka-afford ng lawyer. So,
Yes.
napabilis natin to para magkaroon na siya ng lupa at yung kanyang tinitirahan na for the last 30 years or even for the last 10 years, if you will, talaga makukuha niya na yung lupa na hindi na siya aagawan pa ng ibang tao, di ba?
Yes, Mr. Chair.
That is the purpose of this law.
Yes,
And the
Mr.
only
Chair.
purpose that we want to do is to make it simpler because mapapaso na yan pag hindi sila pinayagan by this law, they will not be able to get it again. Magtatagal na naman sila. So,
Yes.
I don't understand where the conflict lies, quite frankly. You have a comment, Ms. Talabis?
Mr. Chair,
Yes, Ms.
I may
Talabis.
hear.
I miss Andrea. Ms. Talabis, go ahead. You're on mute.
So, good morning po, sir. So,
Morning.
sir, regarding po dun sa comment on the Section 14 of PD 1529 vis-a-vis Section 48 of CA 141. So, this office also concurs with the opinion of Attorney Thompson and Attorney Katigbak regarding the similar provisions. So, it is not proper that we just amend only CA 141 because you need to harmonize. So when we amend CA 141, Section 48, uh, removing the period na since June 12, 1948, 1945 dapat yung possession, we should also amend Section 14. Maybe because yung title kasi ng PD 1529 is the Property Registration Act, kaya baka lang na-confuse si attorney. But if you will read Section 14 of PD 1529, same provision siya dun sa Section 48 of CA 141. So, kailangan dalawa natin siyang i-amend. Kung hindi, magkakaroon na naman ng confusion na sa CA 141, bakit inalis yung June 12, 1945, and then bakit sa PD 1529, naiwan yun. So, we should amend these two provisions at the same time, Mr. Senator. Thank you.
All right. Comments? Yes, Lorena.
Sir, I'm just reading from the case of Republic of the Philippines versus spouses Danilo Go and Amarlina Go, GR 17297, August 2, 2017, wherein the Supreme Court differentiated specifically CA 141 and PD 1529. So I just the comments I mentioned earlier, I just quoted from the jurisprudence that there were these differences were also observed by the Supreme Court in the said case, sir, regarding the difference between PD 1529 Section 14 and Commonwealth Act 141, sir.
Both together, 141 section.
Yes, sir.
Yung decision. Nasaan yung decision? Public Act versus law? Did you show?
Sir,
The Public Act
versus spouses go.
spousal law.
Yes,
Take a look
sir.
at it.
Hello, Mr. Chair.
Yes, go ahead.
Randolfo Mansakir, sir, from LRA. If I may offer an explanation, possible explanation, because you see, Public Land Act 141 was enacted in 1936,
correct.
and it provided for two kinds of obtaining a title. One is through patent, but it also provided for a judicial method,
Yeah.
which is under Section 48.
Hmm.
Wala pa pong PD 1529 noon.
Mm-hmm.
So, ang PD 1529 po kasi 1978 lang po yan. Ang difference po ng obtaining a title under 141 sa dalawang method, pagka patent po, if patent ang ginamit mong pag-apply, you have the applicant must admit that the land that he is applying for is a public land. But he complies with all of the requirements imposed by Public Land Act in obtaining a title for the same. Kaya pagka nakita ng administrative yung sa dati Department of Agriculture yan, ngayon sa DENA, nag-comply na siya, ibibigay yung kanyang patent. Pero the same 141, Act 141, provided also for a judicial confirmation of imperfect title. Dito, ang properties being applied for is already presumed as a private property. But ang presumption na yan, at saka yung qualification ng pag-apply doon sa patent, pareho lang. Pareho lang po. Kung makikita natin sa PD 29 later on, ginaya lang ho yan. So, kina-harmonize yan, pero ang objective po ng proposed bill na ito, ang main objective is to tanggalin na yung limit for filing a free patent. Yun lang naman ho yun eh. But, again, kailangan masagasaan din ho itong Section 48. Kasi kung hindi ho mababago ito, which is pareho siya ng provision doon sa Section 14 ng PD 1529, magkakaroon ng discrepancy. Kaya this is the reason kung bakit this proposed bill, although the main reason for its enactment is the removal of the period for filing a patent. Pero inaayos na rin ho ito, yung hina-harmonize yung Section 48 at saka yung Section 14. Yun lang ho yun, ang sa aking pagkaintindi. I don't see any conflict here. Pareho po kasi yung Section 48 kasi under judicial confirmation of imperfect title din naman yan under 141 at saka yung Section 14 ng PD 1529.
Can you cite that provision again in the law sa Go case? Spouses law? I am looking at it. I'm trying to find out where it is. Lorena?
Hello, sir. Yes, sir. I will just quote some of the statements of the Supreme Court in the case.
Which particular statement are you referring to?
Regarding when they were pointing out the Section 14(1) of PD 1529 and judicial confirmation of imperfect title under Commonwealth Act 141, sir.
Yes.
Under Commonwealth Act 141, judicial confirmation allows for agricultural public lands to be disposed of by the state and acquired by Filipino citizens. On the other hand, PD 1529 provides for the procedure to register a title under the torrent system. Section 14(1) of PD 1529 does not vest or create a title to a public land that has already existed or has been vested under Commonwealth Act number 141. The procedure of titling under PD 1529 simply recognizes and documents ownership and provides for the consequences of issuing paper titles.
It all ends up to having a title, right?
Yes, sir.
Both of them head up towards providing a title to the poor farmer, right?
PD 1529, sir, all kinds of public lands po, it covers registration.
It's agricultural land.
Yes, it also includes agricultural lands,
And we're talking about a private agricultural land here, right?
sir.
We're not talking about any other land here except agricultural land. So that
Um,
they're what you're saying.
PD 1529 um, also states also covers those who have acquired ownership of land in any other manner provided for by law. So pinoprovide po niya yung coverage po niya, all types of lands kahit na po hindi siya agricultural, sir.
What is the manner provided for by law? Under 131. This is what it's citing, right? Those who have acquired ownership of land, how did they acquire that? By sale?
Pwede,
By conversion from homestead? Ano ba yan?
pwede rin pong they acquired ownership of land under Commonwealth Act 141, sir.
Such as?
Sir, yung judicial confirmation of imperfect, sir. So parang it's also covered under PD 1529, sir.
Right. So you're saying we cannot confer title because we have to go through the judicial confirmation of imperfect title, ganun ba? There's no title.
Sir,
There's just continuous occupation, uninterrupted position, and peaceful possession of the land. Di ba?
sir, I'm sorry, napuputol po kasi.
No, what I'm saying is, what you're saying is, ang sinasabi ba, judicial confirmation lang of title ang pwedeng gawin of imperfect title dito mga farmer na ito?
Sir,
Yung
hindi.
agriculture na ito nakatira rito?
Sir, hindi. Pino-point out ko lang po yung difference nung subject matter ng PD 1529, sir, tsaka ng Commonwealth Act 141 on judicial confirmation of title, sir.
The difference.
Yes, sir. Yung subject matter lang po, sir. Nothing against, I have nothing against for the farmers to easily acquire the lands that they are tilling since so many years, sir. Pero yung pinoint out ko lang po, but just for your information, sir, as discussed in the said case, sir, yung difference lang po, sir.
And the difference is basically they acquired it by any other form.
Yung acquisition po kasi yung sa PD 1529 does not vest title, pero yung sa under CA 141, kumbaga it vests.
Title.
Opo, sir.
Yeah, but this is a procedure lang so that we can get final title after a long period, di ba?
Opo, sir, yung sa Commonwealth Act 141 po. Tapos pag na-comply na po nila yung mga requirements sa Commonwealth Act 141, they can then register under the under PD 1529 po, sir.
Which is either by judicial proclamation or by conferring of title by DNR that they have been there and that they are entitled to it, right?
Sir, under Commonwealth Act 141 po yung sinasabi niyo po na kung paano nagkakaroon ng title to the land po yung yung applicant. Tapos po pag na-comply na po niya yung mga requirements po dun sa CA 141, then the land may be registered under PD 1529, sir. Under those who have acquired ownership of land in any other manner provided for by law, sir.
I really don't found it. Di ba under 131 ang mga restrictions yan, di ba? You cannot sell the land for a period of so many years, right? Di ba? Originally?
I'm sorry, sir, napuputol.
No.
Cannot what?
Under Commonwealth Act 141, 141, when you acquire for land, you are given a period upon which you cannot sell the land for a certain time, correct?
Yes, sir. Under the current
And under the same doctrine, we amended those laws by way of Republic Act 15 11 that allows them to acquire title by virtue of continuous possession. Ang problema lang natin ngayon dito, expire na yung kanilang time. Marami nag-acquire pero hindi pa sila nakapunta because I think of poor public information on the public land law. Our objective is to allow these farmers, these people now, to be able to get the title so that they can go on with their lives with a little bit more of security. I don't know how, what you're saying is going to, so you're saying they will be deterred from doing that because of what you're saying?
Sir, no, sir. I'm just saying that the subject matter of Commonwealth Act 141 and PD 1529 are different, sir. And I'm just quoting from the jurisprudence, sir, regarding the observation, sir, of the court before.
But we're not violating that. We're just saying we're creating a law that will now allow them to make it easier for them. So I think we should, wala namang violent objection doon yun eh, di ba? If we file this bill, it becomes a law, right?
Yes, sir. I'm just manifesting some observations regarding the difference, sir, in the subject matter of two
Share
provisions.
duly notes as observations, and I will
Yes, sir.
help my people to say, you caught me unawares here, but I have to check. But in the meantime, if there are no other objections, I would like to go ahead and approve it.
Mr. Chair?
Senator Amy?
Yes, Mr. Chair, I think that these technical observations can be sorted out very quickly. And as you yourself said, agricultural public lands are distinct from the lands covered by PD 1529. I would like to lend full support to this bill, and I think it would be welcomed by agricultural sector. It is also in the general direction of Bayanihan 2, wherein for the first time we have a provision in Bayanihan 2 that indicates that we have waived the loans through this year for all beneficiaries of agrarian reform with a view towards restructuring and even condoning their debt. So nasa tamang direksyon po to, and we really applaud this. Sana nga lang, perhaps the more correct terminology, instead of TCT or OCT, ilagay lang natin torrents title kasi mas maliwanag yon. At welcome na welcome ang deletion of the sunset provision. Full support po, and I hope that we can bring this to plenary kasi bagay na bagay po to sa Bayanihan 2. Sunod na sunod itong titling doon sa ating condonation and waiver of accrued interest. Thank you po.
Go ahead, Calixto.
Yeah, Senator Gordon, Your Honor, perhaps the committee will consider instead of the 74 years to reduce it to cut it to 10 years as you had in the residential free patent. You know, of course, in the bill it's 30 years, but you know you might want to consider to cutting it to 10 years.
Well, I'm you know, I'm liberal insofar as the poor is concerned. This is an opportunity for the poor to have their own land, di ba? That is
Yes.
the whole objective, right? And the longer you have, the longer their poverty is, right? Well, the
That's
Commonwealth Act and all the other laws to protect public land was meant to prevent speculators from this. These are poor people who have been acquiring in their possession. Kung hindi, ang mangyayari niyan, if you look at everybody or everywhere in Mindanao without casting aspersion, yung mga public land laws natin, they circumvent it, and that's why people own 1,000 hectares, 3,000 hectares, di ba? So it's to the mighty, they're allowed to get as much land as they want. Pero ito, Ano ba itong lupang ito? Not more than 12 hectares lang ito eh. Di ba?
In fact, 5 hectares po lang eh.
5 hectares nga lang eh. Oo.
Saka, bino mo, kung miskin na 30 years, magpapakita sila ng tax payments for the past 30 years. Napaka hirap pong pakita yon. So 30 years, I think would be just right.
All right. All those points are well taken. And yes, Eminent Labis. Mr. Labis, go ahead.
Sir, we would like to manifest yung comment or position ng Land Management Bureau of the DNR on the proposed bill. Actually, sir, we have already submitted yung aming position paper 2 days ago. We have emailed it. And we would like to express our support to the Senate bill because this is in line with the efforts of the DNR in continuously working towards the simplification, streamlining, and fast-tracking of the disposition of A and B lands of the public domain. And we find this Senate bill as very relevant, and in fact, we emphasize the urgency, Your Honor, of the enactment of this bill, considering that the deadline for the filing of the agricultural free patent applications is just 3 months away, which is on December 31 of this year. So we had been seeking support from other sectors para maipasa po ito ng mabilis. And that this is also in consonance with the agenda number 6 of our President, Duterte administration, which is to ensure security of land tenure to encourage investments and address bottlenecks in land management and titling agencies. So we support this, Your Honor, subject, however, to some comments on specific provisions that we propose changes po, Your Honor. So first po is on Section 2. Although wala kaming change doon, we support yung removal of the phrase since June 12, 1945 because we believe that this is very difficult to prove, no? And experience tells us, no, yung mga judicial confirmation of titles sa courts na ang hirap i-prove nito because yun nga, since 1945, nagkagera na noon and wala na po talagang ma-produce na record. So, madalas nadi-dismiss, no, yung petitions ng mga tao. So, we are amenable that instead of since June 12, 1945, ipeg na lang po natin sa 30 years under a bona fide claim of ownership for at least 30 years, immediately preceding the filing of the application. So, we are amenable on this, Your Honor. Then on Section 3, Your Honor, we have some changes, no? Because Section 3 of the bill, it proposes an additional requirement from our existing processes of the DNR, Your Honor. I believe Section 3 should be harmonized with the recent ruling of the Supreme Court in the case Suprema Dumo versus Republic of the Philippines, GR number 218269, promulgated on June 6, 2018. Because sir, itong jurisprudence na to, ito na po yung sinusundan ng ating mga korte when they rule on the petitions for registration ng mga agricultural lands na ito under Section 48 of the CA 141. So, in consonance with that, gusto namin i-adapt instead of the Section 3 as worded in the bill, we would like to propose a change, no? Instead of, we would like to do away with the certification requirement or the requirement that the applicant submit a projection map prepared and signed by a licensed geodetic engineer because this licensed geodetic engineer is a private geodetic engineer and that the person, the applicant would still have to pay, gagastos na naman siya, and this is just another layer sa process because ultimately it is still the DNR geodetic engineer who will do the projection and the certification as to the alienability and disposability of the land. So, sa ruling ng Supreme Court in the Dumo case, it requires that the applicant for judicial confirmation of imperfect title must prove that the DNR Secretary has approved the land classification and released the land as alienable and disposable, and that it is within the approved area per verification through survey by the Centro or Penro. So in the said decision, it is necessary that a verification survey be conducted by the Centro to prove that the land is within the area classified or released as alienable and disposable. So then we also took note that the proposed provision ng Senate bill as worded now, nakalagay po kasi na dapat accompanied ng forestry administrative order, DNR administrative order, executive order, or other documents of the over the land. But we take note, Your Honor, with the state of land records that we have today, and due to the fact that may mga napakatagal ng mga lupain na noon pa po na LC map, no? As early as 1920, napakahirap na pong kunin itong mga dokumento na to. So we have an alternative, no? So maglalagay po kami ng additional sentence na sasabihin natin na should there be no available copy of the forestry administrative order, executive order, or proclamation, it is sufficient that the LC map number, project number, and date of release or classification indicated in the land classification map be stated in the sworn statement. So that hindi na po natin hahanapin yung copy mismo. Kasi doon po sa jurisprudence ng Dumo case, pati po yung copy. So nahirapan po yung mga tao, pumunta sa DNR, wala na pong mga copies. So kaya po gusto namin idagdag itong
Just see the verification.
yes sir, na
Verification
parang
lang.
yes sir. I-state lang doon sa sworn statement na meron siyang project number, land classification number, and we believe that it is sufficient po under the presumption of regularity of discharge of public functions, Your Honor. So meron po kaming proposed recasting of Section 3, Your Honor, based dun sa comments ko, if you would like to
Yes,
to
we
hear
like
that.
to submit that to us.
Apa. So, our proposed provision goes like this, Your Honor. For purposes of judicial confirmation of imperfect titles, it is sufficient that the applicant submit a projection map prepared and signed by the DNR geodetic engineer and verified and approved by the DNR secretary or his designated official, showing that the land is within alienable and disposable lands of the public domain. Your Honor, nilagyan po namin ng or his designated official because ito rin po yung problema ng DNR because it is not efficient, no? If all the land classification certification will be elevated to the level of the DNR secretary. So we can just imagine the bulk of work that he has to do. If ang dami po nitong mga cases na to, and it is not advisable that that power is centralized sa secretary. So it will defeat again yung purpose na mabilis ang serbisyo ng gobyerno. So Your Honor, ang nilagay namin or his designated official so that the law itself will give authority to the Secretary of DNR to say na ito si Penro or si Regional Director ang magsasign in my behalf so that may authority na po si Red. So decentralized po yung function, mas mabilis po yung serbisyo ng DNR sa tao. Okay, so to continue po the proposed change in the provision, the projection map shall contain a sworn statement by the geodetic engineer that the land is within the alienable and disposable lands of the public domain and shall state the applicable forestry administrative order, DNR administrative order, executive order, proclamations, and the land classification project map covering the land. And then we add this provision that I said a while ago. Should there be no available copy of the forestry administrative order, executive order, or proclamation, it is sufficient that the land classification map number, project number, and date of release or classification indicated in the land classification map be stated in the sworn statement. So provided that said land classification map is duly signed or approved by the DNR Secretary. So yan po yung aming proposed recasting of Section 3. So to continue, Your Honor, on Section 4 naman po, which seeks to amend Section 44 of CA 141 and Section, we have noted, sir, the deletion, the insertion of the words alienable and disposable, and we are amenable with that. The insertion before the phrase agricultural public land subject to disposition. So we find this as important since it highlighted the requirement that the land must first be declared as A and B before it could be disposed of. So that's for Section 4, Your Honor. And then for Section 5, ito na po yung deadline. Na-check. Okay. So ito naman po yung Section 5. It seeks to amend Section 45 of CA 141. We take note po, na-insert po kasi may or yung DENR region, no? So we believe po na there is no necessity, no? Dapat po sa senro lang po yung filing of application. So our comment is that we suggest that the filing of application should only be made with the senro. And in the penro, in case of provinces where there is no senro. Because, Your Honor, we have na kasi mga implementing penros, so minerge yung ilang mga senros, so nawala na yung ibang senros sa ilang areas natin. So implementing penro na lang. Considering that it is the said offices that determine whether the land applied for is previously covered with an application or not. Kasi po sa regional office, pag doon po sa regional office, doon pa rin po ibababa sa senro or penro yung application. So we suggest that the phrase or region of the Department of Environment and Natural Resources in Section 5 be deleted. Okay, and then still on Section 5, Your Honor, we would also like to point out that the DNR is empowered under CA 141 to resolve conflicting claims involving A and B public lands. As such, it is again suggested that the provision under Section 5, inserting a new Section 45 under CA 141, which allows the conflicting claimants to seek judicial remedies, be deleted. So we believe, Your Honor, that yung primary jurisdiction resides in the DNR. It is mandated under Executive Order 192 that we have jurisdiction over conflicts, controversies involving public lands. Therefore, we believe that resort to judicial remedy would be premature. And considering that we want to unclog or declog the cases handled by the regional trial courts, this provision, as proposed in the bill, will not promote declogging of cases in the court. Okay, and then to continue po, Your Honor, so we have also a suggestion on the rewording of Section 5. So after considering all those comments namin, we have a proposed provision. So if I may read, Section 45, period for application. All applications shall be filed at any time. Okay? Ito na yung tinatanggal natin yung period for filing, yung December 31 na inimpose nung RA 9176. So, shall be filed at any time after the effectivity of this act before the senro or in the provinces with no senro, the application shall be filed with the penro of the DNR having jurisdiction over the land. The senro is mandated to process the application within 120 days to include compliance with the required notices and other legal requirements and forward their recommendation to the concerned penro if the area of the land is below 5 hectares, to the DNR Regional Director if the area is 5 to 10 hectares, and to the Secretary of DNR if the area of the land is more than 10 to 12 hectares, who shall have 5 days to approve or disapprove the patent. So we are amenable with the delegation of authority stated in the provision. So we commend.
To 12 hectares now? Are you saying that?
Yes, sir. More than 10 to 12
It collides
hectares.
with the CAR, greater reform?
Sir, actually, yung effect po nung CARP law to our area limitation under CA 141, which we are doing now, no, is that in effect, 12 hectares pa rin po ang ina-award. But kinukuha po kasi ng DAR agad yun. Because sabi nila, 5 hectares and for every legal air, 3 hectares. So, pwede po siyang mag-exceed ng 5 because kung may mga legal air siya, may retention pa po na another 3. So, meron po kaming internal guidelines with DAR na nasa rules na po namin ito.
Can
But
you
just
pass
to
us a copy of those internal guidelines?
yes, Your Honor.
Direct to the chairman, please.
Yes,
Copy
Your Honor.
furnished lang yung committee secretary. Go
Okay.
ahead.
So to proceed po, Your Honor, so we would like to emphasize the importance of removing the period for the filing of applications for both administrative and judicial confirmation of imperfect titles found under sections 5 and 6 of the bill. So shall be filed at any time na lang po is a very important amendment so that the landowners could now apply for both modes of titling without time limitation. So katulad
Right.
po ngayon, Your Honor, nagkukumahog na po yung mga clients natin because it's just 3 months away. So binabaha po kami ng application ngayon sa DNR for
Okay.
agricultural free patent. So
I
we would
appreciate
be
the
very
point.
happy.
We're already accepting that. Go ahead.
Yes, sir. And then, so that's it, Your Honor, and we are also happy that there is processing time limit put in accordance with the Ease of Doing Business and Efficient Government Service Delivery Act. So that's it, Your Honor. That is our comment. Thank you very much.
Right. We will submit that to us and we will look at it, and when we see that we can harmonize all the provisions as I promised earlier, including the comments of Ms. Lorena. And I'd like Ms. Lorena to be available to us so that she can explain it to us later. And then afterwards, we will call another meeting or we can go direct to committee if that is the pleasure of everyone here. Is that okay with everybody?
Yes, Your Honor.
Yes, sir. Yes, sir.
Senator Amy is still there?
Yes.
Yes po,
Right.
yes po, Your Honor.
All right. All right. Just looking for Senator Marcos. All right. In that case, I will suspend the proceedings. And unless there are other comments, if there are no more comments, I will suspend the proceedings, subject to this the submission of all these proposed amendments by DMR, Land Management, as well as the consideration of the Department of Justice State Councilor Lorena, so that we can harmonize it and we can all be sure what will happen. If necessary, we will have a technical working group so you can practically harmonize it. Would that be okay to everyone?
Yes, sir.
Yes, sir.
Or would you rather we just proceed
Yes,
with
sir.
the technical working group so you can all talk to each other and then we can fix it?
Yes, sir.
TWG na lang tayo, no? Direkta na. All right. So the chair hereby orders the secretary to come up with a schedule for a technical working group that we can make a final copy until when you put up the copy against the original, you put up the copy of the suggestions of the DNR and the concerns of DOJ. Is that okay?
Yes, Your Honor.
Please indicate to me that there are live forms in front of me.
Yes
Raise
po.
your hand. If you're okay, raise your hand.
Yes, sir. We're okay,
Yes,
sir.
Your Honor.
All right. Thank you very much. In that case, I will suspend the hearing. And with your permission, once the technical working group is okay with everybody, I may proceed and have it signed by everyone. Is that okay? So that we can report
sir.
it to the committee.
Yes, sir.
Yes, sir.
Tapos natin ito right away para umabot tayo sa December 20.
Yes, yes, sir.
Yes, sir.
All right. Thank you all
Yes,
very
sir.
much.
Thank you, Your Honor.
Thank you, sir.
Thank you, Your Honors.
Thank you. Thank you.
Thank you, Your Honors. Thank you po.
Thank you, Your Honor.
Thank you, Lorena. Thank you. Thank you, everybody.
Bye po.
Mr. Thanks. By the way, could you text me your numbers, all of you, Miss Lorena? Give it
Yes, sir.
to the your numbers to the Comsec, so I can get your numbers in case I need to call you. I know
Yes, sir.
who to call you, including the other resource person.
Yes, sir.
Okay, thank you. Thank you.
Thank you, sir. Thank you.
Session is recessed or suspended. Thank you. Ang dami mong binibigay sa akin.